Governor Gavin Newsom signed a new bill known as the Tenant Protection Act of 2019 that has taken effect as of January 1st, 2020. Under this new law, there would be an annual cap on the amount of rent that a landlord can increase for qualified tenants. The rent cannot be increased more than 5% plus the cost of living adjustment for the year or more than total of 10%, whichever is lower. If you sign a new lease with new tenants, obviously you can collect a new market rent.
In addition to rent cap, this law limits the number of reasons that landlords can use to evict their tenants. So landlords can no longer evict their tenants because they want to increase the rent or they want to switch their property to a vacation rental or for whatever reason they don't like their tenants. There are 14 reasons that landlords can use to evict their tenants, and they fall under two categories: at fault and no fault of the tenants. Let's see what they are.
Tenants can initiate a reason for their eviction due to their own fault. The biggest one, obviously, is a non payment of rent, criminal activity or illegal use of property, breach of material terms on the lease, like subletting, not allowing the landlord to inspect the property is a big one, or it may be as simple as refusing to sign the extension or new lease when the contract has expired. Now, this doesn't necessarily lead to immediate eviction because the landlord has to give proper notices and give a chance to tenants to cure the cause. But if the issue continues and persists, then landlord has the right to evict the tenant. Now, there are certain causes that, due to no fault of tenant, gives an opportunity to the landlord to evict their tenant. The big one is obviously landlord is planning to occupy the property as a primary residence. Be careful about it. I didn't mention second home or vacation home. Or the landlord is planning to take the property off the rental market entirely. And this can be up to 5 years or minimum of 5 years, depending on the city. Or it may be due to substantial remodeling. And by substantial remodeling, I don't mean partial remodeling or updating a kitchen or changing part of the plumbing in a section of the house. Substantial remodeling requires at least 30 days of vacancy in the house. It has to be by permit and follow certain rules. When the tenant has to be evicted due to no fault of its own, his own or her own, after providing proper notices, the landlord has to give 1 month of rent, which is considered a cost of relocation to the tenants. And this money changes hand within 15 days after they vacate the property and they move out. Now, keep in mind that in Bay Area, there are some cities that they have stricter rent control than this bill. City of San Francisco, Oakland, Berkeley, Alameda, San Jose, East Palo Alto, Mountain View, Los Gatos, and Richmond, as of June 2020, are the cities that have their own rent control rules. And obviously, as a landlord and tenant, you have to seek more advice with the city and follow their rules. Let's put the city's rental restriction aside and see in general who qualifies for this bill. If you are a tenant who has been in the property for 12 months, or one of you has been on the lease for a minimum of 24 months, you fall under this category. In order to be exempt from this law, the property must be a single family dwelling, meaning a single family detached or attached home, a townhouse, or a condominium, and the property cannot be owned by a corporation or LLC, limited liability company owned by a corporation, or a REIT, which is a real estate investment trust.
A lot of small investors may be exempt from this law, but keep in mind, written disclosures is the key. So as a landlord, if you fail to disclose your exemption to your tenant in writing, both of these laws still applies to the contract that you have at hand. So in conclusion, if you are a landlord and you are exempt, make sure you contact your realtor and you provide your exemption in writing through proper forms of California Association of Realtors to your tenants. If you are a tenant and your landlord has not disclosed just cause and rent cap exemption to you, know your right. You may qualify for rent cap and 1 month of rent for your moving cost. If you are a landlord and you are not exempt from this law, do your due diligence. Scan your renters, check their income and their references, and for a start, just to know your tenants better, write a contract for 11 months compared to regular 12 months, because this law applies to terms of 1 year and more. Happy investing, everybody. My name is Nazeri, and I'm a broker in Greater Bay Area, Northern California.